Hi, my name is Shelly-Ann Petz, and I've been urged by personal injury lawyers to share my story of a catastrophic, life-altering accident I was in and what occurred. I'm also speaking out to expose the systemic issues and fraudulent tactics being used by Alberta insurance companies to get out of paying on claims or what should be paid on claims, leaving injured Albertans absolutely financially devastated, on top of living with chronic pain. We were traveling on Highway 22X in Calgary, expecting to have a fun afternoon watching horse jumping at Spruce Meadows, when a truck approaching from the opposite direction made a sudden left turn in front of my van. We T-boned him, spun around. The back corner of his truck collided with the side of my van, leaving my third seat in the shape of a V, narrowly missing my 2-year-old son. 2 collisions and at 93 kilometers and at that location would normally result in fatalities. We survived because of being in a van with a 5-star safety rating, but surviving has resulted in every aspect of our lives being destroyed. I sustained numerous and permanent injuries, and I'm left with lifelong injuries and impairments that requires me to be in lifelong painful treatments, have specialized equipment, and with ongoing medication costs. The tactics used by the insurance company have been far more damaging than dealing with the pain from the injuries themselves. Surviving an accident caused by another driver should not result in a life sentence of pain, poverty, and injustice, which is what has occurred in my case and is occurring in other cases when Albertans are injured in motor vehicle accidents. To help me overcome the injustice, my friend Diana has set up a GoFundMe called Help Shelly Find Justice After a Horrific Accident. Because what has happened to me can happen to any one of you, I ask for your support. Any donation, no matter how big or how small, can make a lasting difference. But I also ask, and more importantly ask, that you share this story to bring awareness about what insurance companies are doing to injured accident victims. If we don't speak out, silence will allow the injustice to continue, and other Albertans will be left living in pain and financially devastated after being in an accident. Unless we expose these tactics and the systemic problems with insurance companies, which is going to be far worse once Bill 47, the Care First model, is implemented on January 1, 2027. I hope by publicly speaking out about what is occurring, it will prevent other accident victims from having their life and future destroyed. What I have experienced is not isolated. It is routine. I know several people who have dealt with these fraudulent tactics since I have, and several people who are currently going through it. Silence will allow the injustice to continue, and other Albertans left living in pain and financially destitute after being injured in an accident. Unless what is occurring with insurance companies is exposed and widely shared publicly, so we can oppose the implementation of Bill 47, the Care First model, which is ultimately no-fault insurance, that's to come into effect on January 1st, 2027. It'll be far worse for injured accident victims in Alberta. I'm going to talk about the tactics being used by Alberta Insurance Company. Shortly after being injured in an accident, our own insurers will send us to their select specialist or doctor for an independent medical exam. Despite the doctor seeing swelling, muscle spasms, seeing the patient in pain, and making comment that they aren't qualified to comment on internal injuries, they write a report saying all injuries have resolved. The purpose for insurance companies doing that is because it's now increased from 10,000 to 50,000 for our Section B insurance cover under all motorist policies, where we are covered up to 50,000 for treatments, for assessments, medications, and replacement income. By them having the false report written by their select doctors, they terminate all those benefits and the loss of income, which means that any further treatments and benefits or loss of income, it's up to the injured party to bear. There's no more coverage for them. It's a fraudulent tactic. In my case, I was sent to Dr. Brent Mainwood, who I then found out from my lawyer was routinely used by insurance companies to cut benefits to minimize the cost that insurers are paying out on claims. Another tactic being used by Alberta insurance companies is they are spending tens and hundreds of thousands of dollars hiring lawyers to undermine claims to get out of paying on the claim or what should be paid on the claim. Insurance companies are routinely sending their injured victims to their select orthopedic specialists. Orthopedic specialists are bone doctors. They are not qualified to treat injuries outside of bone fractures and healing of broken bones. So the purpose in sending people to orthopedic surgeons is, again, to have their specialist write a false report to claiming injuries have resolved, to stop claims from increasing. What happens then, because of the false report, the lawyer for the injured party has to hire 2 more doctors for independent medical examinations to counter the false report that the insurance company has had written for them. Each of these reports costs over $10,000. So it's increasing claims by over 300% because of the false reports that are being written for insurance companies. The IME doctors working for insurance companies will say one thing during the assessment and then write something completely different in the report. As an example, seeing the pain when somebody's trying to lift 20 pounds and commenting that they should not be lifting more than 20 pounds, but then writing in the report saying that they can easily manage 20 pounds. I learned through the process that a lot of senior personal injury lawyers will hire videographers to record the assessments because of the false reports. Videographers are also extremely expensive. Another reason the cost of litigation claims is so high. Insurance companies have hired people to drop money on the ground and then have them videograph the person picking the money up. It's a setup. Obviously, unless somebody has a broken back and is totally incapable of picking money up, it's a natural reaction when you see money on the ground to go and pick it up, even if you're in pain after. The insurance companies are setting up surveillance traps, hiring people to videograph injured parties at a very unusual time, such as on a moving day, when movers and people have been hired for packing and doing the majority of the transportation of boxes and furniture. The injured party only carries a few light items, and that gets used against them. While the injured party had never claimed that they were physically or totally disabled and they were working, there should never have been an issue with carrying a few light items like bedding off of a twin bed and a few items of clothing from the closet. But they then use that as an excuse. They then use that alleging injuries have resolved. Again, another tactic to get out of paying on claims. The insurance companies are dragging claims out, often 10, 15 years and longer. They are doing that to wear people down so that they accept a lower, unfair amount from becoming so financially destitute and desperate. Insurance companies are hiring lawyers to make false statements in court and withhold evidence, despite it being required by the rules of court that everything be relied upon be included in the affidavit of records that gets filed. Case law shows that the non-disclosure constitutes fraud. So in other words, lawyers being hired by the insurance companies are committing fraud to help their client, their insurance client, get out of paying on a claim or what should be paid on a claim. The tactics insurance companies are using, they're fighting tooth and nail to get out of paying on claims or what should be paying on claims, rather than getting unbiased assessments. And despite the UCP finance minister having knowledge, was anything done about it? A government acting for Albertans would be investigating the tactics, fraudulent tactics, why the cost of claims are so high, and would be taking steps to deal with the tactics being used by insurance companies to protect Albertans. Instead, the opposite has occurred, with the UCP supporting their corporate insurance donors at the expense of Albertans and their lives. As set out in articles that I'm going to be talking about now, it is also discussed in articles how the UCP received a $600,000 donation, and as a result of that, they have prioritized insurance companies' interests and are bringing in no-fault insurance to help their corporate insurance donors escalate their profits at the expense of Albertans and their lives. So I'm going to talk about some of the articles that have been written. There are many out there. I've only brought select ones. Fair Alberta, Mark McCourt, who's an extremely experienced senior personal injury lawyer in Edmonton. There's also articles put out by Stringham LLP, Litwinick, by Lloydminster News. There's tons of articles out there, and I really encourage everybody to please review these articles and learn about how devastating the Bill 47 will be to Albertans. We need to speak out. We need to share the information and speak out. One article that has been written, it was written in May 2025, about the Care First plan, which will come into effect on January 1, 2027. Bill 47, no-fault insurance, means higher premiums, limited treatments, and loss of rights. Daniel Smith stated that it is due to the high cost of litigation that they're bringing in the no-fault insurance to bring premiums down. Well, what we will see as we go through these articles, the UCP already know that there will be no savings on premiums, but they are still moving forward with the implementation of Bill 47 on January 1, 2027. Additionally, Albertans need to be reminded that the UCP lifted the cap in 2019. That resulted in the average premiums increasing by 35%. The UCP have shown since they've been elected that they aren't working for Albertans, they're working for their insurance donors, having lifted the cap, which already resulted in the premiums in Alberta, as an example, 2 times higher than BC. But BC's always received higher compensation on accident claims. The Alberta Civil Trial Lawyers Association, Fair Alberta, civil rights and consumer advocates have all been speaking out and trying to educate Albertans about the reality of the UCP's Care First model, no-fault insurance, which will result in higher premiums, less coverage, more insurer control, and no legal recourse, along with the loss of rights. Especially for Albertans who sustain serious or permanent injuries in an accident, and for fatal accidents, it'll be devastating. I'm going to just show you the article. It's a very short article, the first one put out by Fair Alberta. So one of the articles put out by Fair Alberta is called No Fault Favors Insurance Companies. In the article, it says, insurance companies will have more right over claims and payouts. You lose your right to challenge unfair insurance companies' decisions in court. Dangerous drivers no longer have to answer for their actions. And finally, which is sort of separate from the no fault, but history about insurance companies and the premiums they're charging, Alberta's regulator has fined insurers over $6.4 million since 2016 for overcharging and breaking the rules. Now, Care First rewards them with even more power. That, again, is an article that has been put out by Fair Alberta, who has been working aggressively to try and educate Albertans on Care First, the Care First model, but also what the insurance companies have been doing to Albertans. Fair Alberta has acknowledged that they have heard from many Albertans about the fraudulent tactics they faced with the Alberta insurance companies, the select doctors that are being used to write false reports, the long delays to be compensated after being seriously injured in an accident. Fair Alberta has been trying to bring awareness to Albertans about how much worse it is going to be for Albertans under Bill 47 once the Care First model is implemented. Another article by Fair Alberta, No Fault Won't Save You Money, which talks about when the Care First no fault insurance was announced, the government promised there would be $400 a year in savings for auto insurance. After that announcement, there was announcement that premiums for 2025 and 2026 had been approved to increase 7.5% in each of those 2 years. That's before no-fault insurance comes into effect, which already will mean that premiums will be higher when no-fault is implemented. Now, both the government and the insurers admit those savings will not happen. No-fault systems in other provinces and countries have consistently failed to keep costs down, and some are now the most expensive in their regions. When there is no savings, there is no reason to give up our rights, and people really need to speak out and try and stop the implementation of no-fault insurance. Fair Alberta's article called Fair Alberta Response to Bill 47, The insurance industry wins, Albertans lose. It sets out how no fault means less accountability, fewer protections, and more power for the insurance industry under Bill 47. No fault insurance will take away your rights to sue the reckless driver, challenge your insurer in court, or to be fairly compensated after being injured in a crash. It is a dream come true for insurance company executives, but it'll be an absolute nightmare for Albertans. No fault means less accountability, fewer protections, and more power for the insurance company. You can't sue unless the at-fault driver is criminally convicted. Insurance companies decide what care you get, if you get it, and how much you get. If they're wrong, you have to fight them in a tribunal. The options for accountability are extremely limited and voices are silenced. Albertans deserve affordable insurance and not at a cost of our rights, our freedoms, and our ability to get real justice. The government promised better, faster, cheaper, but what we're getting is less, slower, and stacked against us with no-fault insurance. Law Matters put out an article called Bill 47 and Access to Justice in Alberta. It spoke about the surveys that have been put out through the Law Society of Alberta. The response showed that 75% of Albertans said that the right to sue was important to them. 82% of the participants said that they believe in holding bad drivers accountable for their actions. Despite that, the response from the surveys, the UCP have proceeded to implement no-fault insurance. An article by Mark McCord, who's a senior personal injury lawyer in Edmonton, he wrote an article called UCP Insurance Deformed, Raise Rates, Remove Rights. It talks about what occurred in the legislature with the passing of Bill 47, the UCP first care model. Insurance companies will no longer have to compensate the innocent injured victims of those reckless drivers, instead merely pocketing those premium surcharges and padding their plump profit margins. Technically, we already have a care first model with our current tort system. All automobile policies have a Section B benefit coverage. It used to be $10,000. It is now increased to $50,000. So there is immediate coverage for the first $50,000 of treatment and medical expenses by the injured party's own insurer. According to Mark's statistics and article, only one claim out of 1,000 is reaching that maximum $50,000 limit under the Section B insurance. So there is no reason to implement no-fault insurance because for more minor claims, they're already being covered. And there's provisions in place for it. Under the present tort system, an innocent victim of negligent motorists are also entitled to receive full and fair compensation from the careless driver's insurance for chronic pain and suffering, income loss, out-of-pocket expenses, and loss of homemaking capacity. No-fault insurance and the issue of fundamental rights is a matter the Minister of Justice should be addressing, not the Finance Minister. The UCP raising rates while stripping away rights is a matter that our Justice Minister should be addressing, but he has not. It is a lose-lose proposition for Albertans, but the multi-million-dollar insurance industry will be laughing all the way to the bank. As quoted by David Shepard in the article, it's probably an understatement to say that this is starting to become a habit with UCP policies, selling out Alberta to unjustly enrich their corporate buddies. Again, the article talks about the $600,000 donation that the UCP received from the insurance company's last election. And lastly, the UCP is letting premiums soar while taking away rights of Albertans as they prioritize their interests and the interests of their insurance corporate donors. Alberta will be the only province with no-fault insurance under private carriers. All other provinces, such as Saskatchewan, Manitoba, and BC, they have no-fault insurance that are under government not-for-profit plans, unlike Alberta for-profit insurance. Under the no-fault insurance, bad drivers are rewarded and good drivers pay the cost for bad drivers. An injured party loses the right to sue the responsible party. The injured party's insurer will provide a certain number of treatments, and only what is approved they will provide. Anything over and above will have to be paid out of pocket. It again talked about 80% of good Alberta motorists will see premium increases of about $125 when no fault is implemented in 2027. For the bad drivers, which is about 20% of the population, they're going to see their premiums reduced by about $2,500. The bad drivers' insurers will no longer be financially liable to the victims those reckless drivers maim and kill. Alberta economists Dr. Jack Menz and Dr. Chris Bruce have repeatedly warned that the UCP no-fault inevitably will lead to more dead people on the roads. The reductions will be fleeting because increased road carnage leads to increased premiums. The UCP are ripping away rights and freedoms from vulnerable Albertans hurt by reckless drivers. Another article by Mark McCourt, Don't Care, No More McCart, Insurance Deforms. The article addresses how citizens no longer have the right to seek remedy through the courts for wrongs perpetrated against them, which is a gross breach of our fundamental charter rights. Innocent Albertans injured in motor vehicle accidents will no longer be entitled from careless drivers' insurance companies unless the guilty driver is charged and convicted of a criminal offense, which almost never happens. Albertans will have to rely on their own insurance coverage under a no-fault system administered by a profit-driven private auto insurance industry. Mark's article also again talked about the 7.5 increase in premiums for 2025 and again 2026, which will mean premiums will already be higher. There will be no $400 savings when no-fault insurance is implemented next year. The NDP had spoken in legislature, pointing out that as a comparison in premiums from when the NDP were in power to the present time, or specifically since the UCP have been voted back in, when the NDP were in power, insurance premium increases were capped at 2.5%. And since the UCP have been in power, well, they lifted the cap. As I mentioned earlier, in 2019, after the UCP got voted in, premiums had gone up 35%. So while the NDP were protecting Albertans, keeping their rights in place and premiums down, the UCP have gone the opposite direction. Again, it talked about the 80% of good motorists that will see the $125 increase in premiums in 2027, while bad drivers' premiums will go down. It also pointed out that the hailstorm in Calgary cost the insurance industry billions of dollars. Well, that's an excuse that they've used to raise premiums. In fact, insurance companies themselves have insurance coverage. It's called NatCat, NATCAT, reinsurance. So they actually will only pay a small portion of the billions from that insurance claim. The insurance company's insurance through NatCat will pay the majority of that loss. No fault, which removes the rights of innocent Albertans to recover injury compensation from insurers of bad drivers responsible for car crashes, violates the principles of fundamental justice. Okay, Mark McCourt's article called "The Care First Fiasco, We Told You So." It again addressed the $400 savings that the UC promised, which will not come about. The premiums will be higher. It also spoke about the Finance Minister Nate Horner, who himself has said that the premiums are likely to increase from between $136 to $400 per year under no-fault insurance, while rights are ripped away from innocent injured victims of careless drivers without reducing rates for good motorists. No-fault insurance, such as in Saskatchewan and Manitoba, have seen higher rates of car crashes, which inevitably sends premiums higher, particularly when insurance is delivered through for-profit insurers like we have in Alberta. Law Matters wrote an article, "Open and Shut, the Case Against No-Fault Insurance." Like Mark McCourt's article, it again pointed out under our current tort law system, we already ultimately have a Care First model where our Section B, we have Section B benefits under our own insurance for up to $50,000 in treatment. And very, like Mark had said, only 1 out of 1,000 do they exceed those, so there's absolutely no reason to move from the tort system. The tort system, however, does need to be revamped because of the high cost of litigation. And that means an investigation. Mark and the Civil Lawyers Association have made recommendations to the Insurance Bureau of Canada, IBC. They have made recommendations under our current tort system to make improvements. And that improvement could be such as there being one doctor agreed to between both sides who will do a unbiased report, and both sides will rely on that report. That will alone will cut the cost down significantly when there's not there's only one independent medical exam instead of 3. That's just one example. And putting time limits in place, and there are things that can be done if people are inclined to make the system better and keep premiums down, not just help insurance companies increase their profits at the expense of injured Albertans. The article also discusses what has happened in serious cases in BC, and that there are numerous constitutional challenges in B, asserting the system violates charter rights. Private market no-fault insurance are consistently among the highest cost auto insurance, while eliminating the rights for injured Albertans. A Law Matters article called Bill 47, An Access to Justice in Alberta, it states Minister Horner stated it does not take away the right to sue because Albertans won't need to sue, which is hogwash, quite frankly, because under no-fault insurance, there's no assistance for housekeeping capacity. It's an extremely low, unjust breach of our charter rights in terms of serious injury and death claims. So, yeah, there's definitely a need to sue. It's not just, I should also point out that Nate Horner also had said that the key thing is closing claims quickly to keep the cost of claims down, which is, again, why they send injured people to their select doctors to write their false reports so they can shut those claims down quickly, and the insurance companies can minimize what they have to pay out. That's under our tort, well, I guess it would apply also under no fault, but it's currently our tort system. The Automobile Care First Tribunal will be established, funded by private insurers in place of existing court remedies. A claimant who disagrees with the decision of their insurer can appeal to the tribunal, whose decision is final and conclusive and not open to question or review in any court. Bill 47 will operate similar to WCB. There are shocking numbers of lawsuits against WCB because of the tactics that are used to do everything possible to not pay out on claim or minimize what is paid out on claims. Justice Bennett of the BC Court of Appeal stated that the public must have assurances decision makers are independent, and Justice Bennett felt that this was not possible with the structure of tribunal established by a province to be seen to deal fairly with claimants, with the reason for the existence is keeping rates low, which is saving insurers money. The results of the Canadian Bar Association survey done through Manano showed that 75% of the respondents stated that the right to sue was most important to them. Personal responsibility and accountability rate is even higher at 82%. Albertans are largely in the dark about these impactful changes to automobile insurance and what they mean. This is due to misinformation. Instead of telling Albertans they will not need to sue, like Albertans ought to have been told before the passage of the Bill 47, that the legal right that they hold dearly will be eliminated on January 1st, 2027. A recent article by the Canadian Press outlines the low compensation injured Albertans will receive under no fault. The conservative critic for the Attorney General in BC stated, people are paying good premiums and they're not getting much back. And seriously injured victims are being denied justice through our court system. On May 22nd, 2025, an article was put out by Fair Alberta called Albertans Aren't Buying It. No fault insurance won't save consumers money. It only takes away rights. It sets out the responses from the Albertans to the Nano survey once again. The 75% held the right to sue most important, and 82% was holding the responsible driver responsible. 47% of Albertans responded that it's unlikely our premiums will drop at all, and only 19% responded believing that premiums will go down. So most Albertans are realizing that there won't be a savings, but rights will be lost. The results of this survey found that Albertans want a system that upholds personal responsibility and access to justice, not one that shields bad drivers and protects Alberta insurance companies' profits. The Alberta insurance industry has enjoyed record profits in recent years as premiums have soared for drivers. Yet, rather than targeting these windfield profits, the government is pushing a model that will further empower insurance companies while stripping consumers of their rights. Fair Alberta's article called Alberta Releases Draft No-Fault Insurance Regulations, critics call alarming. As part of the article, the meat chart that assigns the fixed dollar value for specific injuries ranging from a loss of an eye to the loss of a pregnancy. The details are included in the proposed permanent injuries. The draft regulations expose the harsh reality of the proposed no-fault system, which features fixed payouts for life-changing injuries and no right to challenge an insurer in court. The fixed payouts are not automatic, as the draft regulation gives the insurer the first say in deciding whether an injury is considered permanent or not. The Alberta government predetermines what injuries are worth, and the insurer decides who's qualified to be paid at all. The Alberta government and the Insurance Bureau of Canada have already admitted that no-fault insurance will not produce the promised $400 in savings that were promised when the announcement was made. An article put out on October 22nd, 2025 by Fair Alberta, it's called Alberta Releases Alarming No-Fault Insurance Regulation. In the article, it sets out portions of the government's draft, the meat chart, the proposed lump sum payments for injuries or death, which is beyond grossly low, unjust, and a severe breach of our charter rights. Under the proposed schedule, if an Albertan loses a pregnancy, if it's under 20 weeks, it would be a payout of $13,234. Over 20 weeks is below $14,000, so just slightly higher. Losing your color vision would result in a payout of $945, while a moderate that permanently changes cognition and employment capacity is valued as low as $38,000. That will prevent a person from being gainfully employed the rest of their life. But yet they will be financially devastated while living with their limitations and impairments. Fixed payouts are not automatic, as insurers get the say on whether an injury is considered permanent or not. The link for the full draft of the proposed meat chart is Permanent Impairment Regulation. Anybody can read it. You just have to Google, and if you put in permanent impairment chart, I believe it automatically comes up for Alberta. But you can, it's in draft form, but it's online for everybody to view, and I encourage everybody to take a look at it so you recognize how low a payout will be if you sustain permanent injuries or death. An article by Law 360, lawyer raising concerns about Alberta's no-fault auto insurance plans, covered claims by Nathan Newdorf, the province Minister of Affordability and Utilities, who claimed it's about keeping more money in Albertans' pockets. But yet, as all the research has shown, not only did the UCP know that the premiums won't be lower, with all of the articles that have been put out and research done showing that the payouts, that the premiums in fact will be higher, along with the Civil Trial Lawyers Association, Fair Alberta, all the personal injury lawyers, and even the response from Albertans to how opposed they are to the implementation. The UCP have continued with drafting the proposed meat chart and bringing in no-fault insurance next year. Aaron Sutherland, Vice President of the Insurance Bureau of Canada, stated, rising legal costs are one of the key drivers of premiums drivers pay in Alberta today, and action to address these present the greatest opportunity for improved rates. Again, I reiterate, as any personal injury lawyer will state, it is due to the fraudulent tactics, the specific, inappropriate specialists that get hired to write false reports, and the excessive costs of litigation claims with having to get additional reports to counter the false reports, hiring videographers to counter the false reports. This is what's driving the cost of claims. And the lawyers, hiring lawyers to lie in court, in my case alone, the cost for their lawyer was into the millions because of it being a serious highway accident and an almost 1 month trial. But it could have been settled at a fraction of the cost, at a fraction of the time, if they weren't so busy trying to undermine the claim to stop paying out at all. Again, I will reiterate, any personal injury lawyer will state it is due to the fraudulent tactics insurance companies are using to undermine claims to get out of paying than just pay out the injured party. They hire lawyers to lie in court and to breach rules of court. The lawyers' fees alone are into the hundreds of thousands of dollars. So they've opted to pay hundreds of thousands to fight claims than pay a significantly lower amount to settle a claim with an injured party. Oh, the article that was put out by Law 360 had also talked about a senior personal injury lawyer in Calgary by the name of Craig Gillespie. He was interviewed, and his comments were as follows. He pointed out that under no-fault insurance, essentially the insurance companies are acting as judge and jury about what is best for your claim and what it is worth. He also stated, so not only are they going to be making decisions about how much an injured party should get, it's also about what type of treatment they should get, how long they should get the treatment, and those decisions will be made in the context of accounting to shareholders and generating a profit with the Alberta for-profit insurance companies. Jackie Halpern, another very senior personal injury lawyer in Calgary who works at McLeod Law, spoke on behalf of the Alberta Civil Trial Lawyers Association, and she stated, no-fault insurance strips Albertans of fundamental freedom, which is the right to sue at-fault parties and hold insurance companies accountable through the court of law. Albertans will pay more in premiums only to receive fewer consumer protections, loss of their rights to challenge insurance companies in court. The already profitable insurance companies are now empowered more than ever in Alberta's system and will reap all the benefits under the no-fault insurance system. The Alberta Civil Trial Lawyers Association, along with Fair Alberta and generally the personal injury lawyers across the province, have denounced the proposed permanent impairment regulation. Both the lawyers pursuing rights for the injured active victims and Fair Alberta stressed the importance of fighting back against no-fault insurance. It will cost more, and it will be detrimental to Albertans in every way while removing rights. To try and prevent the implementation of no-fault insurance, all Albertans need to write their MLA opposing the implementation of Bill 47. They also need to write Alberta's Finance and Treasury Minister, Nate Horner, and ensure that they copy the NDP Finance and Treasury Shadow Minister, Court Ellingson. The UCP are notorious for hiding complaints that they receive for Albertans, but by the NDP critic getting a copy, it holds the UCP accountable to address the complaints they're receiving from Albertans. Despite the majority of Albertans stating in the surveys put out through the Canadian Bar Association, which ultimately was through Nanos, they have proceeded. I also want to point out that in one of Mark McCourt's article, it talks about that at the UCP's meeting in November of 2025, the majority had voted against no-fault insurance. But despite the majority voting no-fault insurance, Daniel Smith has proceeded. So people have been speaking out, but we have to speak out more. In fact, another article written by Mark McCourt spoke about, because of the NDP bringing in no-fault insurance, they almost got voted out in the last election. And if it's felt that if they continue with the no-fault insurance, with the number of complaints, people who have gone to the media talking about not getting approved for treatments that have been approved by their doctors. So people are having to choose between getting treatment approved or recommended by their doctors or paying the necessities of life. In a lot of cases, they simply cannot get the treatment because they can't afford it. There are lots of articles out there from people in BC about not getting the treatment that they need. There's a death claim in BC. There's a class action or a charter claim over the low payouts for a death claim. So if BC continues on the same path, it is very likely that they will lose power in BC, and I expect that in the future they will probably go back to the tort system. I will also point out that under the tort system, the Alberta courts will not use BC case law. The payouts in BC are 2 to 3 times higher than what Albertans receive, so the Alberta courts will not allow the case law out of BC as a precedent for what an injured Albertan should receive. This should be a message to all Albertans, no matter which party you support. It is a non-partisan issue that affects all Albertans. It should tell you, no matter what party you support, that the UCP are not working for the interests of Albertans. They have prioritized their own interests by getting large amounts in corporate donations from their insurance donors, which is going to be devastating to injured Albertans, particularly those with serious injuries and or death. The UCP's Care First model, it will leave everybody without adequate and needed treatment, having to pay out of pocket for treatment and equipment if not approved. And believe me, what they will cover is really bare bones. It may not even be offered, and injured people will be left financially devastated, particularly if serious injuries are sustained or permanent and they have no recourse. Okay, I'm also going to point out that while the insurance companies have full control over what, if any, treatments are approved, we can only expect that the cost for medical treatments are going to go up, which in itself is going to cause premiums to increase and probably less treatments to get approved when insurance companies are forced to pay higher costs. I'm going to talk also about what is occurring at the present time with insurance companies. I'm hearing from people that a lot of the insurance companies are already handling claims like they are under the no-fault insurance. 2 people have told me that family members were in automobile accidents recently, and while they got the other driver's insurance company particulars, when they reported the accidents to the insurance companies, the insurance company told them that they did not need the other driver's insurance information, even though the other driver was the at-fault driver. On Christmas Eve, it was the 4th time that I've heard since approximately the summer of, might be a bit before, but approximately the summer of 2025. I've now heard from the 4th person on Christmas Eve that even the damage claims are being delayed. The 4th person told me it is over a year and the damage claim for their vehicle still hasn't been resolved. In the past, the damage claims would get resolved pretty quickly, usually within about a month. And now, because the insurance companies know they've got Albertans over the barrel, they've got the UCP ignoring what they're doing, supporting all their tactics, so they're taking full advantage of it. A friend of mine told me that he's waited 4 years for the damage claim on his vehicle to get resolved. And like I said, that's the 4th person. So they're already operating under no fault. And, you know, it's such a gross breach of Canadian insurance laws. Honestly, this really needs to go international because we pay premiums to be protected in the case of losses and damage. But yet, despite paying the higher costs, Albertans are not getting the coverage they're entitled to receive. And it is a gross breach of our rights and something that we really need to address. I have spoken to many families who have gone through what I have, including, professional people, the banker at ATB. Oh, would I like to help you? My father went through the same thing. He didn't even get back his loss of income. Well, there's another case, the couch case, that sadly for them, like myself, ended up with Justice Sullivan, who's known throughout the legal field to be anti-women, to be anti-personal injury plaintiff, and to rule on bias. There's been numerous news articles about him ruling on bias and how cases have been appealed. In Mr. Couch's case, which was just reported a couple of years ago, he was injured in an accident caused by another driver. It was a 2-week trial. He received $3,000. Like I said, he was in treatment for 2 years, but he didn't lose income. And Justice Sullivan justified the $3,000 judgment, stating that he wasn't permanently injured, that it went back to court for costs. Justice Sullivan's judgment was only 20% of the cost that he paid out for treatment. Another person, another client of my lawyer's, she ended up with IQ of less than 70. Like he said and claimed in my case, credibility. We both had 2 independent psychiatrist, extensive psychiatric assessment, who had stated, both psychiatrists in both cases, there was no malingering. And Justice Sullivan wrote in his judgment that there was malingering. She has had she obviously, at an IQ of 70, which is considered mentally retarded, she cannot work. She had to declare bankruptcy. I'm still fighting. My friend, his claim was settled in 2023. He was a mechanic. He lost 2 years of work. And his lawyers settled his claim for a total of $100,000. He paid $70,000 out of pocket for treatment. So that means he netted $30,000 for losing 2 years of work. We need an investigation done into our current tort system. We need oversight of the current tort system so that we aren't paying 300% more for IMEs, having to get, videographers in the thousands of costs because of the false reporting. It is long overdue for Albertans to stand up and speak out about what our Alberta government is allowing these insurance companies to do. They are to represent us and protect our interests, not the donors, or donations from their corporate donors. My story is not just about my struggle. It reflects the documented pattern of misconduct of Alberta's insurance system. A government working for Albertans would investigate the fraudulent tactics being used. They wouldn't be prioritizing their own interest by helping their corporate insurance donors escalate their profits with a no-fault system that denies coverage for medical treatment and strips away rights from Albertans while premiums increase. I hope speaking about my case and about what is going on with the Alberta insurance companies, the tactics they're using, and what's happening to Albertans who are seriously injured in Alberta after being in an accident caused by another driver, that this will bring some awareness as to the unjust that is occurring. And now, in most cases, most claims are settled because lawyers are afraid to go to court. Any lawyer will say they can walk into court with an airtight case and come out losing, or they can go in with the wonkiest case and come out winning. It appears that the UCP is also trying to control the judiciary. Now, it obviously depends on the judge we get, but, as has recently been announced, the UCP are also trying to control the appointment of judges, which, if we can stop the implementation of no fault and the tort system remains, the judge that hears cases is critically important. When there's a judge like Justice Sullivan, known throughout the industry to rule on bias, be anti-women and anti-personal injury plaintiff, to keep somebody like that on the bench, it is such a gross injustice to all people and is causing people to be absolutely devastated. I recently had a lawyer tell me that if he walked into a courtroom and saw Justice Sullivan, he would turn around and walk right back out, that there's no way he would allow that judge to hear a case. So, there's a huge risk going to court because of the judge. And, there's different philosophies out there. I also had a lawyer tell me that she did not believe that people had permanent injuries and ongoing pain after being in an accident until she was in an accident herself. And then she had said, oh my God, do I have sympathy for people now? The pain I have gone through, and it's just not going away. I am still in treatment. So the reality is, we have insurance laws in place for a purpose. We need judges who enforce the laws, and we need a government that is protecting Albertans' rights. And we need to stop the implementation of Bill 47. No matter what party you support, you need to realize that it is a nonpartisan issue and that you could be next. Any one of us could get out on the road and be injured in an accident caused by another driver. Do you want to be financially devastated, lose your career, lose your home, lose everything you have because of a bad driver that's caused an accident? Speak out, Albertans. We need this stopped. It is nonpartisan. And I am going to speak out as much as I can to share information about the tactics being used, because it is a gross injustice that is happening. We cannot afford to face premiums while being stripped of our rights and living with lifelong injuries after an error by another driver, and have our lives and future completely devastated, which is what is happening to injured Albertans in Alberta, the seriously injured Albertans in Alberta. I encourage everybody, no matter what party you support, to pay attention to the devastation that will occur to injured Albertans, particularly those who sustain serious and permanent injuries, and speak out. This is a nonpartisan issue. This is an issue that affects all Albertans. Anybody can be in an accident when they get on the road that's caused by another driver. Do more people want to lose their home, lose their career, lose everything they have like I have because of an error made by another driver? Please, Albertans, speak out. We need this stopped. We need fair compensation for people who get injured in accidents caused by other drivers. We don't want people living in the street because of the UCP letting their insurance donors strip Albertans of rights and not even pay fair amounts to obtain needed treatments. I ask for your support. What has happened to me can happen to any one of you. Any contribution, no matter how big or small, to my GoFundMe, again it's called Help Shelly Find Justice After Horrific Accident. It can make a lasting difference if you're able to contribute anything at all. But more importantly, share this video by bringing the GoFundMe to the attention of others. Hopefully, it will result in further support from more Albertans, but it also provides a lot of detail about what occurred with the insurance company and at trial. And share this video. I am speaking out not just for to try and get help to overcome the injustice I face. I'm speaking out for the sake of all Albertans. We need to stand up and speak out together. That is what is going to make a difference, is if we all stand up, speak out, and against the injustice that will occur to no-fault insurance. So please share the information and please contribute anything you can to the GoFundMe, because I want to protect other Albertans. So I am going to continue speaking out because I don't want to see more people go through what I have. And when I should have been killed in that accident, I'm struggling just to exist, and it's getting harder by the day. So please share the video And let's stop this. We don't want more people getting hurt by insurance fraud and the UCP.